Welcome to Under the Basswood Tree with Basswood Counsel, a podcast where we bring you brief, valuable conversations and insights to help you navigate the complex world of business transactions. From cross-border deals to international tax structuring, we cover topics across all industries. Our team and colleagues will share their insights and provide practical tips on key issues for you and your business. Let's get started.
Welcome to Under the Basswood Tree podcast with Basswood Counsel. I'm Jephte Lanthia, a partner and co-founder at Basswood Counsel. My practice covers corporate securities, where I advise clients on issues and financial services regulations. From a startup raising capital for its first round to a public company accessing the capital markets, from a fund manager launching its first fund to an SEC-registered investment advisor navigating SEC compliance, and broker-dealers working through the full spectrum of starting, operating, and growing a FINRA member firm. Today, we are fortunate to have with us Erik Dolan of Key and Compliance. Erik has more than 20 years of experience in financial services, having worked for several large brokerage firms, as well as investigator for FINRA. So, Erik, go ahead and tell us about yourself.
Oh, thank you. Yes, Erik Dolan, Key and Compliance. And I've been working with this firm now for the last several years. I had previously worked as a compliance consultant with Erik Compliance, and we were bought up by Foresight and then ACA, and worked with them for a few years before starting my own. Prior to that, I was in-house compliance and regulatory compliance. I'd spent time with FINRA and the MSRB and the CFTC over the years. I've worked in dealer, institutional, retail, and registered investment advisory compliance.
Thank you, Erik. Before we start, I must give the regular disclaimer that nothing we say should be construed as legal advice. So if you need more advice, feel free to reach out to us at Basswood or reach out to Erik. We'll provide the contact information at the end of the podcast. So Erik, again, so before we start, I guess let's say, I always tell clients, when we start to talk about securities regulation, so you start with the backdrop of the 1920s crash, right? Well, I'm a former school teacher, so I always go back. So you can start with that, where the 34 Act created the Securities Exchange Commission with the missions of investor protection, facilitating capital formations and efficient markets. And broker-dealers play a big role in fulfilling those missions. And I think, so broker-dealers make the securities world go on. And so having said that, what exactly is a broker-dealer? And when should someone start considering whether they are acting as a broker-dealer?
So are you asking me to define a broker-dealer, or just sort of like if somebody, a client wants to ask if they want to start a broker-dealer?
One thing I see often in my practice, clients don't always know what a broker-dealer is, right? Right. And I tell people, if I had $1 every time a client comes to me that they try and raise, they try and raise capital or try to assist, a company in raising capital, I'll be rich. But, you never pay. So that's why I'm here. We know that the Section 348 of the 34 Act define a broker-dealer, someone who's effecting securities transactions.
I would say that's the broker-dealer. The easiest way is that they're facilitating security transactions. They're either executing trades for clients or they're buying and selling securities for themselves. But the world is so broad and there are nuances depending on different business types. Legal definitions matter because as you work in different business activities, you can cross lines into regulated broker-dealer activity.
And the easiest one that the clients are often miss is, their thing is a finder's exemption, where they think, well, I can help a company, find investors. And that's where, at least, from a lawyer, that I see clients get into issues. But let's say a client agrees that he or she is a broker-dealer. Mm-hmm. So they come to you, say, I want to start a broker-dealer firm. Walk me through the process.
Yeah. So if they come to me and say that, right, the first thing I say is, because oftentimes they're already, they're either in the securities business or they're entrepreneurs. It's sometimes not always from the broker-dealer world. They may know what a broker dealer is intuitively, and they understand it because maybe they've worked on the other side of it. Maybe they're on the RIA side and other transactions. But I always let them know that, you're not starting a traditional business the way you're used to. You're applying to become part of a regulated system, right? Your business model has to be approved by FINRA in order to operate, right? I think most people do come in and they're thinking about their opportunities. They're thinking about the revenue. They're thinking about deals. They're thinking about clients. What I think sort of falls short sometimes is that, the regulators are thinking about investor protection. They're thinking about risk and supervision and capital, right? As the broker dealer, does it have the financial wherewithal to operate? So, that first conversation is always really about sort of aligning. Does your proposed business model actually fit within what FINRA will accept and approve? And, can you support that business, operationally?
I agree, and similar to something that we do, or I do as lawyers. We do as lawyers. When clients come to us, it's trying to understand what is your business model, right? What exactly you trying to do. Understanding what is the client is trying to do, uh, allows you to give them better advice. And to your point, which is also something we should point out, we have broker dealers, right? People who are offering brokerage services, execution, and we have registered investment advisors, right? Sometimes you'll find brokerage firms that involved in both activities, but clients should know, if I am in the services of effecting securities transaction, I'm getting paid through commission. I'm in the broker dealer lane. And if I am being compensated for advisory services, I'm in the investment advisory lane. Again, which is a separate regime, separate regime under the SEC and state law. But sometimes we do see overlap. Let me say for our listeners, we wanted to point that out.
Yeah. Yeah. No, I think you hit the nail on the head, right? Our registered investment advisors, they basically give advice, right, for a fee. It could be on portfolio strategy or manager selection, asset allocation. And at the end of the day, the actual buying and selling of securities or placing deals, if they're a private placement broker dealer, right, that's broker dealer activity. It's affecting transactions. But, there is drift, to your point, where they may get a little bit mixed up, right? RIA starts going beyond advice. Maybe they start introducing clients to a specific deal. Maybe, especially really is that I think it's when, when they're getting compensated based on whether or not that client invests. Right now, you're looking at broker dealer activity. And I've seen the flip side too, where the broker dealer sort of starts shifting. Well, we're just advising on this. We're just consulting, and but they're marketing the deal. They're talking to investors about the details. They're getting paid based on the deal closing, right? So, so I don't know if there's a dividing line necessarily. I mean, there is a dividing line, but it's not always clear with a label and a sign, right? I think a lot of times it's behavior, right? If you really are only advising and you're staying in that lane, then you're pretty safe. You're in an RIA territory. But if you're driving the transaction and you're getting paid for that, I think you're going in the other side.
I'll put a shameless plug. That's when you call your lawyer, right?
It's right. Well, there's a lot of firms that live in both worlds too, right? That's the tough part. There's the same parties, the same names and phone numbers and addresses, but their hat, they forget what hat they're wearing sometimes, and you've got to be careful and really work with them so they understand that and keep it straight.
And to your point, it is a tenuous line. I don't know if you remember in 2020 when the SEC issued a Reg BI, right? Reg BI, and I think the SEC also issued a interpretation. What is the difference between a broker dealer and investment advisor, and services activities that are incidental, right? So is that incidental? Again, it's not always clear, but I would say, Frank, are you getting paid for commission, for execution, or recommendation, or are you getting for ongoing long-term investment advisory advice? So if you're not sure, check with compliance, check with legal.
Yeah.
So again, so the client comes to you and they they've decided that they're going to the whole broker dealer route and filing from BD. How long is the process? So, I mean, what do they need, and how long is the process from, okay, I'm engaging you to I'm running, to FINRA approving my BD form?
Yeah. So they first have to file the new membership application, right? That's the big one, right? And it's it's a very difficult, it's a rigorous process. From my experience, I would say it's the most rigorous onboarding process in the industry. Right? You're being asked to prove, right? Both on paper as you send them documentation, but also in practice that you can operate as a compliant broker dealer from day one, right? And you have to provide a business plan. You have to provide your supervisory structure, your written supervisory procedures, financial projections, and if you have clearing arrangements, if you're going to be clearing through a firm, your technology vendor, the stack, they call it the technology stack, experience of your personnel has to be defended and disclosed, right? And then FINRA they'll test everything. They'll ask you questions. They'll challenge your assumptions and your model. And, what they're really looking for at that point, I think, is consistency to make sure that everything makes sense and fits together.
As I understand, FINRA, I get under rule that 1014 has like 14 standards that they look at, and basically, again, you mentioned all of them. Most of them are net capital, business plan, personnel. So against those 14 standards, and that's how they make determination.
Yeah, they do. If you just miss one, you get discouraging language. Well, they'll email you and they will say that it is not substantially complete. So your application has not been accepted. You go in and you look and you say, I missed one question. And it's funny, but you have to complete everything. And then there's follow-up, right? There's a lot of back and forth after that.
One of the requirements of 14 standards is the net capital requirement.
Yes.
You've referenced it a few times. What is it? Why do we have it?
And no, it's a good question. And the real experts in net capital are the financial and operations principles, which I'm not one of, but I do have a good understanding of net capital. I've been doing this long enough, and I work with enough FinOps over the years. They call them FinOps. So the net capital rules, really, they're there to ensure that the broker dealer can meet their financial obligations and that they don't pose extra risk to the customers or the market for that matter, right? It's really fundamentally about the liquidity and stability of the firm.
And you're right. It's a question with it. I guess this way you're a fan of. We'll talk about it, about that later. But again, back to our earlier point, investor protection. As I understand, because client always ask me, what's the difference between the net capital requirement, right? Between civic requirement and between bond, fidelity bond, right?
Right.
Again, going back to your point about a list of things that they have to show. And as you mentioned, the net capital requirement is to protect the investors to the extent that the firm, is dissolved, something. So investors, there's enough capital.
Yeah.
And I think, as I understand, it's a backdrop to the extent the net capital requirement does not come through specific Securities and Investor Protection Corporation, similar to the FDIC. It covers, those that. And of course, bonds, the fidelity bond protects the firm to the extent that employees, hurt the firm.
Right. And I do typically request that they put me on their fidelity bond just in case. I've never had any problems, any issues, but I always say, put me on just in case. It's better to protect myself in case somebody else does something outside of my purview and I don't know about it either, right? So, yeah, those are all in place to protect not just the firm, but the investors are protected as well. But the firm sometimes has to protect itself.
And one thing we mentioned, and I think you referenced it again, to your earlier point again, I think going back to that because it's very important to your earlier point about activities, right? What exactly are you doing? Which also aligns with the net capital requirement, right?
Yeah.
Depending on your activities, whether you are, just an introducing firm, whether you're a current firm, you have different levels of net capital requirement.
Yes. And yeah, people misjudge those sometimes too. They don't realize. I think there's the net capital, and then there's sort of the reality of how much you might need in year one, right? That's so they don't always appreciate that things can cost more than they expect.
And I'll segue to that has for budget. Then you have to budget for a month and budget for ongoing. And you mentioned FinOps, right? So what is a FinOps, and when does it make sense to either hire a outsource a FinOps or have the FinOps internally?
When does it make sense? Yeah, the FinOp itself, like I said, it's the financial operations principle, right? It's a critical role in a broker. They're responsible for financial calculations, all the reporting, filing, compliance with net capital rules. They make sure that the firms can meet their financial obligations. They are, like I said, they're critical. If the net capital is wrong or if your filings are off, there could be immediate regulatory problems, right? So firms can end up being restricted from doing certain types of business by the regulators. They could be shut down very quickly. So I always, while, oftentimes sales kind of drive revenue in most businesses, it's the FinOp that really make sure that the firm stays alive, right? Stays compliant. And even for me, the FinOp firm, is critical to my role because they provide me with the resources to do, to make sure that I'm covered basically to do my job as well. As far as you asked if they were being, when it makes sense to outsource versus bring in help.
But say, to have a FinOps, you have to have what, the 27, the CB's 27 or 28.
Correct.
Yes, so you need one, a FinOps.
Yeah, you need one. And they're similar to me, right? You outsource for simplicity, you outsource for cost. I think for, it depends on it's not a clean answer. I know it's a tough question because, every firm is different, but, if you have a small or a mid-sized firm and they have a very specific business line and they're kind of focused, they're honed in on that line, the outsourcing oftentimes is the best route, right? It's clean.
Okay.
If you find a good FinOp and they know what they're doing and they've been around, they're going to do a good job and it's going to be at a more reasonable price.
Okay.
Now, if you're a big wirehouse and you have tons of different business lines and business lines within business lines, a lone FinOp probably won't have enough bandwidth, right? So the firm is going to have different levels of expertise that they need. So someone in-house that needs to oversee and supervise their team of financial professionals who will then, it might make sense at that point to bring it in-house. But every firm is different.
Makes sense. So let's switch gears to compliance and WSPs. What are they and why important?
WSPs, written supervisory procedures, right? They are probably one of the most misunderstood components of a compliance program, right? Yeah, they're supervisory procedures, not compliance. And there's a difference between supervision and compliance. It gets muddled, right? It does, because the supervisors work with compliance to make sure that there's a structure there. But the written supervisory procedures create a blueprint, sort of a structure, and firms will sometimes treat that as a document, right? It's a document that we have to have. If the regulator comes in, they don't look at it as a document. They look at it as evidence of a system, that there is a supervisory system in place. The WSPs, right? You need to know, right, who's doing what and when they're doing it and how supervision's actually happening, right? The sort of the nitty gritty. And, they should cover, at the very least, you want them to cover your business lines. You want them to cover your supervisory structure. In instances where an escalation path might be required, you want that covered. You want specific review procedures, right? Because you're required to, you want to review emails. You want to, if you have trade blotters, you want to review trade blotters, outside business activities, private securities, right? And then how the firm sort of complies with all this is right. Those are key under FINRA, right? But sometimes WSPs aren't written well. They're just very generic. copy paste type language. They don't always reflect how the firm actually operates. And I think the key is really when you're putting together WSPs, you really want to test them against reality, right? Like, what is the firm really doing, right? And if your team can't, follow the WSPs, if they just can't do, then maybe something's wrong, right? If they can't follow, or they can't prove that they're following the WSPs, something's wrong, right? Then it's not, then it is just a document. And quite frankly, it's no longer an asset or a controlled type of document. It's more of a liability at that point because it's in writing and you're not doing it.
I agree. I certainly give you. I always tell clients that even in the investment advisor world, you do what you say you are going to do, right?
Yes, absolutely.
And WSPs are required on the FINRA rules, so it's a requirement.
Yeah.
And sometimes folks try to cut corners, download the WSP online, which again, or now, even now with AI, generate one through AI. But I always advise them, you need a professional, what is a lawyer or a compliance personnel to sit down and understand your business and see whether what you have on paper aligns with your the services that you are providing. And again, going back to our earlier point, knowing the client's business, again, so you can better protect them. And how you said, when SEC or FINRA comes to an investigation or exam, they are holding you accountable to what you say that you're going to do.
Yeah, absolutely.
Well, I mean, you mentioned a few. What have you seen as far as like failures, in the WSP? You mentioned people confusing them with compliance manuals, which are different. I mean, what other failures, or deficiencies have you seen as far as like WSPs?
Failures, there's oftentimes when it's a WSP failure, right? It's usually a failure to supervise, is what they're usually saying, right? It's so a good program, it's not just about what's written, it's about, like I mentioned, what's happening day to day, right? Is everything being done? Are communications being monitored, trades being reviewed? Failure to supervise, because what happens is I think there's a couple of reasons. The policies are either lacking or there's a gap, right? The procedures say one thing, but the firm's demonstrating that it's doing something else. And it's not always that the firm's doing something inherently wrong or egregious, but they do have to, you want the WSPs to really, they have to be reviewed and updated, and you want them to read like an actual description of the business, not an aspirational document. Because the other problem what people fall into is they create this beautiful document with all these what they think are great, great requirements that they're going to hold their firm to, and it's way above and beyond what the rule book says. And then the firm is in violation of no other rule other than they didn't follow their procedures. I'm all for, I think you should go above and beyond whenever you can. I'm all for it. But there are times where I say, are you really able to do this and prove that you're going to do this? Because I've seen firms get in trouble for that, where it's like, guys, this isn't even the rule. This isn't even, you're way beyond the standard of the rule. And if you can live up to that standard, then you should, but you don't have to put it in the WSP, right? We can scale back. FINRA's not going to judge you based on, not going above and beyond the rule. As long as you're up to the rule, they're going to be okay with that. But you have to make sure that, and there are areas where you can put up a little bit more and make it, you have to know what you're able to do. But I think for me, that seems to be the most, I've seen that over the years where they just weren't doing it. The other thing too is when a firm, sometimes the business lines won't always treat compliance. Most firms are really good about this now, but over the, in the past, with the compliance is, it's a cost center in the eyes of some, right? And they may not be invited to all the meetings, so they don't necessarily know that there's a new activity happening. So now there's nothing in the WSPs to cover this new activity. So when that happens, nobody knew, right? So there's nothing, or at least compliance didn't know, and they didn't talk to the supervisors to get it, make sure. So that's why there's, dialogue's very important, to say the least. So you'd have to have meetings with the firm, make sure that you're not missing anything. But over, in years past, I've seen that happen as well.
And I'll piggyback to a point that you made about drafting the WSPs. Again, that's when clients, I guess, are paying for experience, right? You would know, I would know, but you would know, again, drafting WSPs, to your point, it should not be so aspirational that it brings more liability
Yes.
than you want. So again, that's when experience comes in, right?
Right.
So that's what they're paying you for, for that. So say, well, as a securities lawyer, I can appreciate, and as a securities lawyer having looked at the SEC, I can appreciate clients who want to have full disclosure. It makes my job easier. It makes your job easier, right?
Yes.
But there's that line where don't give the secret sauce,
Right.
right?
Right.
You bring more liability than you need, so again, is that, line again, which again was that with experience. So that's what clients again should reach out to, compliance professionals, and lawyers to assist them with the process. Still, speaking about compliance, and another requirement for broker dealers is record keeping.
Is what?
Record keeping.
Mhm. Yeah.
Yes. So can you speak to the record keeping requirements, and what have you seen in your experience, as far as clients having it or sticking with it?
Yeah. I mean, I think for the most part, it's been pretty good. I think people do sort of fall by the wayside. I can tell you that there's been a few areas where I've come into firms where maybe when it usually happens is when the former compliance officer left, a year ago, and they haven't been keeping up with everything because that person did and they did everything right. And then, the people kind of try to keep up with it. So you see them incomplete oftentimes is probably the biggest thing. Like I'll see outside business activity or private security transaction record approvals, and they're not signed by compliance, right? Or there's no date, or the supervisor didn't sign them. So it's there, it's in the file, the employee, but nobody ever signed off saying it's approved. And they say, oh, I told them it was approved. You see, you see that line that says supervisor approval? Yeah, sign that, right? And, so that's, I would say the biggest. Now, overall, I probably should kind of come back to this, but the record keeping requirements for broker dealers, they all sort of come down from the SEC, right? 17A, 3 and 4, right? And FINRA sort of builds out from that. And really, those two rules, though, if you really pay attention to those two rules, you're right. 17A3 tells you what needs to be kept, right? What needs to be created,
how long,
and then 17A4 tells you how long, right? And you're looking at 3 to 6 years usually for most records. But FINRA does expect you to define what you're keeping. They want you to know that, they want you to know what you're supposed to keep, how long you're supposed to keep it. And usually at the back of the WSPs, there's a chart that says, these records are kept for 3 years, these are kept for 6 years, and it lists everything. So it's not anything too terribly difficult. There's certain formats that the SEC requires. If you have electronic records, they have to be kept in certain formats under 17A 3 and 4. So you have to make sure that that's done if you're using outside vendors, for example, to help you with your record keeping.
And something you mentioned earlier, I'll clarify, you mentioned outside business activities. For our listeners, what is that? What is it? What is the implication of it has for supervision, and what is the implication of it has for record keeping? So can you, I guess, briefly bring it all together, outside these activities?
Yeah, and outside business activity could, really it's anything that you're working on outside of the broker dealer. And there's often confusion. I'd rather people err on the side of caution in this regard. So I always tell people, if you're getting paid for it, disclose it. It doesn't matter if it's in this industry. It doesn't matter if you're driving Uber on Saturdays or working at your family's restaurant. Just disclose it. You want to know about it. You're getting paid for it. We should disclose, right? There's a financial incentive. When you're not getting paid, it's a little more gray, right? And I tell people, if you're coaching your 4-year-old's soccer team, that's fine. Nobody cares. It's fine, right? That's great. That's nice of you, but it's not, but if you're the treasurer of your homeowners association and you're controlling where the funds might go, I usually have them disclose it at that point because there is some influence over cash, right? And that's sort of my rule of thumb with outside business is, but I always say when in doubt, and even if you're not the treasurer, if you're the president, the vice president, the secretary, there's probably a good chance you can influence. And I would just, disclose it. We know about it because, there's oftentimes it's sort of an ignored when there's not an initial problem or an issue or concern, they become ignored. And I think where with outside businesses, reps will disclose the activity and then that's kind of the end of it. And you go, oh, okay. What you should be doing is sort of, whether in writing or not, you should be sort of assigning a risk to it, right? You should know, working at the family's restaurant, not a problem now, but there needs to be follow-up, right? Because what if they decide to go private and do an equity raise and they want to now franchise 3 years from now and you're missing something, right? Now there's security activity. And before they were only helping mom and dad waiting tables, right? It was, that was it. So things can progress, they can evolve and get away from you. So, I keep a running log of all, not just the forms that they sign for the approval, but I keep a running log of everybody's outside businesses and I send that to them every year. Has anything changed with this? Talk to me. What are you doing? Are you still doing it? Is there any change in the business? Nope. We're good. Okay, fine. I'll talk to you next year about this. But at least you can kind of keep up with it a little bit more if you're keeping a running tab of the activities. And I think that's something that a lot of firms just don't do. They look at it and say, oh no, that's just their parents' restaurant. And then you don't know that something, all of a sudden there's a left turn that you're completely unaware of. And then you get into securities activities and you didn't know about it.
Good point. And still sticking with supervision and record keeping, something you mentioned earlier, I want to go back and take it. You mentioned off-channel communications.
Yeah.
That's a big one.
Yeah.
Well, what is it? What are the risks? And what are the risks, particularly with social media and technology?
Yeah, absolutely. Well, all electronic communications have to be archived, right? And they have to be archived in a system that's controlled and tamper-proof, right? As much as possible. And I mentioned the 17A4 requirements. That would be the worm, write once, read many. It has to be, that's an SEC requirement, right? Which, you basically have to have indexing and you can search these, and they have, the firm that you're using has to promise that they could, they're keeping these emails under this, compliant within this, right? So where you end up missing, right, as you mentioned, off-channel communications, right? If you're only retaining the emails and people at the firm are using their personal phone to send text messages or WhatsApp, right? Or anything else. There's others that, they just kind of keep coming up and Signal, I think was one of them, right? If they're not being retained, and this is what was happening, you'll probably ask me about this at some point, but this is, that was happening, over the last several years. And the regulators came in, the SEC really kind of started the charge here. They found emails where somebody said, oh, hey, I got your text. And it went into a lot of detail about business, to answer your questions. And they went into all this detail. So then they said, well, wait a minute, was the text retained? And it wasn't. And doing it, people don't think much of it because it's so easy to text, right? It's so easy. It's so much more convenient, but you can't. And unless it's being retained. So the SEC goes and they realize, wait, there's all these all these people in the firm are texting, and none of these records are being retained, and it's all about business. They're texting clients. So now your firm has failed to keep and retain the required books and records around these communications. So now it's a books and records violation over a text message, right? And depending on how many, how long it went on, the firms were astronomical. The fines rather were astronomical for the firms.
And again, those are issues again that firms should consider again when they are starting operating, and again having it included on their WSPs, have manuals to address those.
Yeah, and most of the tech companies have caught up. Most of the companies now they are able to archive WhatsApp and text messaging and even LinkedIn messaging. You don't really see people using Facebook or things like that, other, certain social media sites, but LinkedIn still happens. But the tech vendors have now they've caught up and they're on board now. I don't think that they even thought of it as a need. I don't think it was that they couldn't do it. They just, it wasn't any. People always thought of electronic communications as emails, even though you mentioned text in your annual training every year. You mentioned, people just think of it as email. There's these blinders but sometimes it takes a real good hard slap for people to wake up,
Yeah.
And that's unfortunate, but that's what happened.
You mentioned a few times this is a SEC rule, this is a FINRA rule, and so I guess I'll step back, for our listeners, to I guess put it in context. So for listeners, and you feel free to start as well. So basically, the 34 Act created the exchange and so to regulate the markets and broker dealers. FINRA, SEC delegated there are some of the authority and supervision to FINRA. So that's how we get FINRA. So FINRA is not a government agency. FINRA is it a for-profit or non-profit? It's for-profit, right?
It's a self-regulatory membership organization.
Yeah.
But yeah.
But FINRA is not a government entity. So FINRA has certain rules that it creates for its broker dealers who are members to follow. At the same time, broker dealers are still subject to the overall SEC rules. So when Erik mentioned this is a SEC rule or a FINRA rule, so for our listeners, that's the context. So, again, because broker dealers are in the securities industry, so they're still subject to general SEC, fraud, and other, rules from the SEC.
Yeah. And quite frankly, oftentimes, not always, they have their own rules, but FINRA will oftentimes eventually piggyback, and their rule language will largely match the SEC's in all ways.
We hope you enjoyed this episode. To stay up to date with the latest legal insights and Basswood events, please follow us on our Basswood Council LinkedIn page and visit our website at www.basswoodcouncil.com. Thanks for tuning in, and we'll speak to you next time.